first-year experience. I have the pleasure of introducing Professor John Culhane this morning, who will be giving you a glimpse into that first-year experience with the torts experience. Like all of our faculty, his experience is vast. I could talk the entire time allotted for his first-year experience in course this morning about him, but I'm only going to take a minute to share with you a few of his accomplishments. Professor Culhane received his BA with honors from the College of William and Mary, his JD from the Fordham Law School. He joined the Widener Law faculty in 1987 and teaches torts and a variety of health law courses. Professor Culhane is the director of our Health Law Institute. He is also a lecturer at the Yale University School of Public Health and a senior fellow at the Thomas Jefferson University School of Population Studies in Philadelphia. He has written dozens of articles for law reviews on a variety of subjects including torts, public health law, gun policy, LGBT rights, and compensation for man-made and natural disasters. He is the author of hundreds of blog posts on his own site, worthyandedgewise.org, and I recommend that you take a look at that. He is a contributor to Slate magazine, where he writes on compensation and liability issues, and to 365gay.com, where he is a weekly columnist. He edited and contributed to the just-published book, Reconsidering Law and Policy Debates, A Public Health Perspective, published by Cambridge Press. He is featured in the 2009 documentary, America Betrayed, which looks at the government's role in Hurricane Katrina disaster and in the September 11th compensation. He speaks widely on these and other subjects, and he has spoken and been quoted in such diverse places as National Public Radio, the New York Times, ABC News, Voice of America, Dissent Magazine, and the Philadelphia Inquirer. According to a recent article, which you've heard mentioned already this morning, and which is contained in your packet, Professor Culhane has been named as one of the 23 law professors in the country who you need to take and experience a class from before you die. So without further delay, please join me in welcoming Professor John Culhane.
All this talk about dying, and you're all so young. I mean, I wouldn't think that people need to take law professors before they die at all, but it was a nice honor. So today I want to talk to you a little bit about, or sort of give you an experience of what a torts class would be like. And the way I'd like to do that is to take an example from a recent decision and sort of run it through a torts analysis and see how it comes out, okay? So first I want to ask you, and you'll see immediately that law school is an interactive experience, right, whether you like it or not. So some people would prefer to hang back, but we sort of invite you into the conversation, okay? So my question is, from a torts perspective, okay, which is compensating people for civil wrongs, all right? So what kinds of interests should the law protect, okay? Another way of asking that is, what sorts of things don't you want somebody else doing to you, okay, for which you might seek compensation? And we're not talking about criminal law here, and we're not talking about contracts. We're talking about something personal that somebody else does to you. So what's the most obvious thing that you don't want people doing to you? Would it, yeah?
Probably things affecting your health or well-being.
Yeah, like what? What would be the clearest example of that?
Medication or something that causes harm or death.
Okay, so medication can be a good thing, right? So somebody forcibly giving you medication, something like that?
Medication that doesn't work the way that it's supposed to.
Okay, so you might want to sue a drug company for a pharmaceutical that didn't work the way it was supposed to, or had a side effect that was undisclosed, right? But that's pretty sophisticated for the first 2 minutes of your mock class, so you might as well sort of move to second year already. But I'm asking for something even more basic. So what don't you want people to do to you?
Take away your home.
Take away your home. Okay, so you're interested in your stuff, right? So you don't want people to trespass on your property, right? You don't want people to take your property. You don't want people to take your personal property, your real property, any of that stuff, all right? But even more than your stuff, which we all love our stuff, right? Even more basic, okay? We don't want people hitting us, all right, pretty much. I mean, if you're a boxer, it's a different story because you're consenting to that. You don't sue every time somebody, delivers a right to you because, after all, that's what you were getting into, right? But generally, if somebody comes up on the street and knocks you down, we would mostly agree that you should have a lawsuit against that person, all right? Why? Why should you have a lawsuit against that person? So things that seem obvious once you get to law school will turn out maybe not to be as obvious as you thought. And the why is the part that we're really interested in. So why is it somebody knocks you down? So why do you have a claim against that person? Yeah, in the back.
You feel like you need to be compensated?
Well, yeah, I'm sure you feel like you need to be compensated, but for what? What has happened to you? What?
Your pain?
Your pain. Okay. Okay, your pain. So you might or might not have an injury that you can detect with an X-ray or whatever, but you might have some pain. And one thing the law does is compensate you for your pain. By the way, is that an easy thing to do? No, because what's the value of pain? I don't know, right? A jury can basically make up a number, but the idea is we think that the right not to have a pain inflicted on you intentionally by somebody else is important enough that you have a claim and you can get money damages because that's the best thing we can do for you, right? Well, the only thing we can do for you. But what if you don't even have any pain? So let's say instead of harming you, somebody spits in your face. And they're in sort of a disturbing number of these cases in the torts casebooks, by the way. So that's all that happens. Somebody spits in your face. Do you have a claim for that? There's no pain.
There's no actual pain, but you still go through different stress, and you still have some kind of pain, but not physical pain.
Okay, so there's some kind of pain there. But really, is that really what we're most interested in that case? Yeah.
Well, there seems to be a good amount of embarrassment that would happen.
Yeah, there's an embarrassment. It's an affront to your dignity. You know, you got to wipe the thing off. You know, I mean, it's not really about the pain. It's about the dignity. All right. So part of what we're trying to do is to figure out what the harm is, and then to compensate you in some reasonable way for a dignitary harm. Right. So compensate you for that. What other kinds of damages do you think you might receive in a case like that? And maybe you've heard of that. Yeah.
Or if it's physical pain, it can affect you later on in life, where you couldn't make the same kind of money or do the same things every day that you might have done without being knocked down from this.
So I'm guessing you moved away from the spitting case now, because you would think at some point you might get over that one, right? But if it's a serious injury, right, some of your compensatory damages might include work-related losses, hospitalization, that sort of thing. Okay? If it's more of a dignitary assault, then we're compensating you for that. But your compensatory damages might not be that great, would they? I mean, you can see why they wouldn't be. So what other class of damages might we want to impose? Yeah, punitive damages. And the purpose of that is to get people to stop doing it, right? So this person would say, well, the compensatory damages in that case weren't so bad. I've got a lot of money. I'll just go around spitting on people, throughout the greater Delaware region, right? So for that reason, we want to let people have some other kinds of damages. We could talk a lot about punitive damages and whether they make any sense in a civil context. That's a reasonable question to ask. But the law has long recognized it. Okay? So, dignity, compensation for harm are two of the things that we're concerned about. Okay. What if somebody takes a swing at you and misses? And that's the end of it. And they say, well, that's it. That's all I've got. I threw a punch. I'm out of here. Luckily for you, you can identify them and you bring a claim. No physical injury, right? No damage. Let's say emotionally it didn't damage you. You wouldn't be able to prove that. There's some dignity, right, that you're concerned about. What else? What other reason might the law have for letting you have a claim in that situation?
Who's to say that the person wouldn't try to do it again to somebody else randomly, or do it again to that person in particular? Okay,
that's an interesting take on it. Okay, so let's see if we can unpack that a little bit. So are you concerned about what they did to this person, Or are you concerned about what they might do to someone else, or is it both?
Well, they could just be a threat to anybody. I mean, if they're randomly going to start swinging at people, I mean.
Okay, so we might, so for the same reason we impose punitive damages, we might want to impose compensatory damages against somebody who does something like this, because after all, they're a menace, right? And we don't want people to be taking random swings at people. Sooner or later, they're going to connect,
Right.
right? I saw a hand up. Yes?
What about the fact that they still attempted to do it?
Well, that's, yeah. So the idea is that they attempted, and it's an affront to your dignity whether they hit you or not. And the idea is that we don't want people who are at the receiving end of this blow or near blow to take matters into their own hands, right? So if we provide some kind of civil recourse, some kind of a remedy, they might be less likely to do that. Now, most people, as a practical matter, are not going to sue somebody that tries to punch them and misses. Okay, why not?
If you miss that person can still suffer from psychological damage.
Yeah, they could.
From
They
now
could.
on, whenever you think of somebody, you'll get scared or something, so that can lead to a lot of.
That's right. That's right. And so part of it is emotional stuff. Let me tell you. Go ahead. Yeah.
I think living in this society, you have an expectation that you don't have to be on guard for all your life. If you walk around without having to be worried about
People taking swings at you,
whatever.
and then having no recourse against it. So the idea is we have the criminal law there, which is already, trying to stop people from doing this kind of thing, and the tort law is kind of a supplement. And by the way, historically, the tort law, right, grew up as sort of a supplement to the criminal law. Okay? So we were mostly concerned about the things that would breach the peace. So obviously a battery, which is what we call an intentional contact against someone else, that's unprivileged, not the boxing match, right? Okay? That obviously is in and of itself a breach of the peace. But something called an assault, which is a near miss, is considered likely to lead to a breach of the peace, and we don't want people constantly running around doing that. So by giving them a tort claim, the idea is that that's less likely to happen. Okay? And the spitting cases, that's a battery, and even if you spit and miss, that would also be actionable, but now we're getting to cases where the damages are so limited, right, that most people wouldn't bother to sue. You might have trouble, as a practical matter, finding an attorney to take the case. Okay? Unless the person you're suing has got a lot of money, because punitive damages are the one place we look at the defendant's wealth. Because we're trying to make it hurt a little bit. All right? Okay. So the law long recognized, this is all, by the way, sort of a prequel or prelude to the stuff I really want to talk about for the next 15, 20 minutes, which is a relatively new tort. Okay? So let me sort of background this for you a little bit. We've just talked about battery, right, which is an intentional infliction of harm. We've talked about an assault, which is just short of that, sort of the swing and the miss, the attempt to cause harm or contact. As of about 110 years ago, courts started recognizing a new tort. And now we're suddenly concerned about the psychological well-being of the plaintiff sort of in and of itself. Okay, so let me give you a few examples, and you tell me whether you think the person should have a claim. So the first example is this, and this was the first case, by the way, with this new tort. A woman is at home minding her own business, and this neighbor, whom she doesn't know very well, comes to her door in a state of apparent hysteria and says, your husband has been in an accident. He's been run down, I guess by a horse at this point, maybe there was a train, but he's been run down. His legs are smashed up. You'd better come and retrieve him. And for some reason that's been lost to the ages, he said, and bring pillows. I don't know what that was supposed to do. So she's too panicked to sort of listen to reason. She gathers up the pillows. She goes to visit her husband. He's fine. Legs aren't smashed up. Okay? She then brings a suit against the miscreant whose idea of a practical joke this was. Okay? And the court allows recovery. What are your thoughts about this? What else do you want to know about this case?
Well, did the woman who showed up at the door intentionally make
The
the
guy
story?
should have.
I'm sorry, the guy, did he make the story up?
Oh, completely. So the first question is, was he misinformed himself? Did somebody else tell him this? Was he just relating information? No, it's his idea of a practical joke.
Right. So then it's, there's some kind of intention on his part to put her in this state of distress.
Okay, so he intends to put her into distress. I think we could probably say that. Or at least he was reckless in doing that. In other words, he didn't care whether she was in distress or not. Yeah.
What about if causing her to be in hysteria about her husband, she drives 100 miles an hour down the street and she crashes into a train?
That's a very good question. I refuse to answer it, because that will take us down a whole nother road. You also are about to advance to second year of law school. That's a very good question. Sort of things that happen that are sort of directly related to what goes on, and the answer is typically yes, you could recover for that. But let's just say that she doesn't suffer sort of anything like that, okay? Your question gets at something related, which is what are her damages, right, more basically. Yeah?
Well, I think psychologically, if it's a horse that trampled her, every time she sees a horse, she might freak out.
Oh, no one's been trampled.
Or, I mean, it's...
But she might associate horses with her non-trampled husband, right? Her potentially would be putatively trampled husband. Yes?
Would it be this repetitive action come into effect?
What's that?
And that numerous times in the past said things to make her panic like that, so it's becoming a problem?
No, this was sort of her one and only exposure to a miscreant, okay, as far as we know. I mean, any other miscreant adventures are not disclosed by the record. Yes?
I would be curious about whether she had any type of past relations with that man, like whether she had...
Would believe him or not, or if he was like, oh, this guy.
If she's done anything in the past to make him upset or angry.
Oh, I see. That probably still wouldn't justify it, right? So just because the guy is a complete jerk doesn't mean he gets to go up and say, I know, I'll fix her with this story about her husband's snatched up legs. One question, yeah, go ahead.
Was he mentally ill? Why did he do this?
Because he was a jerk. I mean, you know, there are such people. In the legal terms, you look at legal encyclopedias under jerk, this guy's picture, right? I mean, he was a jerk. And so it doesn't excuse him. You're looking for things that might get him out of liability, get his liability reduced. There's nothing like that in the case. But what are her injuries? Yeah.
Well, it's a trust issue. I mean, from now on, like, how is she supposed to know when or when not somebody's telling the truth about one of her family members?
Okay, but do you really think that she's going to, like, every time someone comes to the door, it's like, I think it would take more than one incident. It's like, oh, by the way, now your grandmother has been, someone dropped a, Acme anvil on her or something, and, so you should run. I think she's going to still believe that. I mean, if it happens all the time, then she needs to move. All right? What kind of a neighborhood is this? Yeah. Well, it is intentional infliction of emotional distress, and what I'm trying to get at, right, this was the first court that recognized that tort. What I'm trying to get at is what should be the elements of that tort, right? Because every tort has elements that you have to fulfill before you can recover. So already some of these have been mentioned, which is the intent. This is a weird tort because even though we call it intentional infliction of emotional distress, right, if you're just reckless, which is not quite as bad as intentional, but you really don't care about the result, you just, anybody in this position would think it's more than likely somebody would be emotionally distressed. So intentionally or recklessly causing emotional distress, that's that piece of it. We need conduct that's extreme and outrageous. Do you think that conduct is extreme and outrageous? Most people would, right? I mean, you could disagree about that, but most people would think it's extreme and outrageous. Who gets to decide whether it's extreme and outrageous?
It has to pass the reasonable person test.
But who gets to decide any of this? The jury. That's a good guess. All right. Whenever I ask this question in torts class, I say you really only have two guesses here, right? The jury or the judge, right? There's no sort of oracle or anybody else we can appeal to. So it's either one of those. And in this case, okay, the prevailing view is that the judge gets the first crack at it. Okay, so the judge will decide whether he or she thinks there's enough there that's extreme and outrageous before even letting the jury get it. Why? Usually something like this would be a pure jury question. It seems like a question of fact, whether something is extreme and outrageous. Why might we want the judge to sort of take a first pass at this before we let the jury decide it?
The jury would be a bit emotional in that sense of determining whether it is outrageous.
Well, isn't that good? I mean, you know, come on, feel something here, right? This person's been injured. Emotions aren't necessarily a bad thing. Yeah.
The judge would obviously have more experience just by the passing of time on the law and how to apply different.
In general, maybe, but it could be a new judge and apply the same thing. We really, right, this, go ahead.
It costs less. I mean,
Oh, I see. We have to sort of litigate, we have to go through the whole trial just to get rid of this. I mean, yeah, there is that, and I think that speaks to something more profound, which is that we're concerned about the discretion that we might give a jury, which speaks to your point. We don't mind them being emotional, but we don't, right, this tort, because there's not someone about to be hit, right? We want this tort to be used sparingly. Okay, and therefore, we want the judge, at least many jurisdictions, many states have said, the judge gets the first crack at it. The judge thinks there's enough there that it could be considered extreme and outrageous, which is usually defined as going beyond the bounds of civilized society and leading a reasonable person, who mentioned a reasonable person? You did, right? To exclaim outrageous. I don't know why you have to exclaim exactly that word. But, you know, then it could be extreme and outrageous enough to get to a jury. But we want to use this tort only for the worst cases. All right, so we need intentional conduct, right? We need extreme and outrageous conduct, okay? We need something else. We need a result, right? We need a result.
Is there a result? I mean, at the end of the day, would the wife be relieved that her husband isn't damaged?
Oh, did I mention she had a miscarriage? I'm sorry, I might have forgotten to mention that. She was very pregnant. I didn't really forget, by the way. Her damage was she had a miscarriage a day or two after this was disclosed to her. And those were the damages she was claiming. Courts have said that the severe emotional distress is actually a requirement for this tort. Now note, in battery or assault, we can bring the claim without any damages, because the law so values you're not being hit or almost hit for reasons that we've already discussed and described, right? But for this tort, built into the very definition of the tort and the requirements are that you suffer emotional distress and that it be severe. Why? I'll follow up with you. Why? Yeah. That's by the way, a common law school first-year student trick. Who's the guy? I don't know. You.
You know, could you definitely root the miscarriage in this isolated incident?
No. But that's what juries are for. Okay, so the jury will decide, and in a civil case, you only have to find by a preponderance of the evidence, which is just slightly more likely than not that the miscarriage was caused by distress. You know, 1897, I think, is the year of this case, so maybe we would have a different view of it today. Different experts would testify as to the likelihood. But there are causation problems, right, that are implicit, really in every case, by the way. But you can really see them jumping to the fore in cases involving emotional distress, because there's all this background noise that you have to filter out in order to be able to discern what the additional stress was and the additional physical results were that were suffered as a result. But the law requires severe emotional distress and usually some kind of objective manifestations of that. Yeah?
I was just going to ask while we're on the topic.
And we are on the topic.
Is there any consideration for the amount of time the person was kept in distress?
Yes, yes. And so usually these extreme and outrageous conduct cases, there's usually a course of conduct, right? But in a case like this, is a little unusual because there was one specific thing that happened. All right? And so those cases are harder to win. There was a famous or infamous case a few years ago where a woman sued former President Clinton for intentional infliction of emotional distress for what she perceived as unwanted sexual advances toward her. And the court threw it out because they said it was a one-time event, and even though it was horribly offensive, and she might have other claims, that it didn't, even that didn't rise to the level of extreme and outrageous conduct for purposes of this court. Now, other courts might agree, or disagree, I should say, but it shows you how high the threshold is for something like this. And I think the court was also noting that, at least in her pleadings, her emotional distress didn't seem to be as severe as courts generally like to see for something like this. Yeah.
Is there some type of psychological evaluation that like we could have a psychologist could do to like measure?
Yes, it happens all the time. And in fact, if you're a litigant in a case like this, right, you have a fool for a lawyer if they don't have you get psychologically evaluated, because that tends to be the best evidence. I want to show you, I want to put this into a little bit of a context, and I want to highlight a recent case, okay? But it's not a case that you might think of as a torts case. So I would say within the last 3 weeks or a month, the U.S. Supreme Court decided a case by 8-1, okay, in which they said that the members of the Westboro Baptist Church had a First Amendment right to picket the funeral of this dead soldier. And so people are looking at this as a First Amendment case, which in an important sense it is. But the First Amendment was used as a defense to tort claims. Okay? And there were a couple of tort claims that were brought forward in the case. The two most serious ones were invasion of privacy, which for reasons I won't get into, really wasn't met in this case. Right? So the serious one was intentional infliction of emotional distress. All right? Before I get into the case a little bit, I want to show you just two very brief clips that, it's always better if these things actually work. Let's see. The first one is Margie Phelps, who is the daughter of the patriarch of the Westboro Baptist Church, Fred Phelps. Margie Phelps is an attorney who argued the Westboro side before the U.S. Supreme Court. And whatever else you think about her, she's a smart lawyer, okay? The second person you'll hear is Albert Snyder, who was the plaintiff and who was the father of Matthew Snyder, who was killed and who's on combat, and whose funeral is the issue. Okay, so the first one, here's Margie Phelps for 30 seconds. Oh, I should probably turn up the mute. It's so helpful. Here she is.
Knows the law. The commitment in this nation is wide open, robust, public debate, up to and including the most outrageous talk, and the ultimate response, as the
Can you see it kind of?
is an adverse emotional impact. That's the words of the court. Let me put that in some colloquial street talk. You hurt my feelings. The
Okay.
First Amendment says
That's enough of that.
$11 million. And at the end of the
Okay,
day,
so at trial, Albert Snyder was awarded $11 million, most of the punitive damages. It was remitted by the judge. The punitive damages were cut from $8 million down to $2 million. There were $3 million in compensatory damages. So a total of cash and prizes of $5 million as opposed to the $11 million that the jury had awarded. So she's talking about the $11 million, but by this point, we were down to $5 million, which still isn't chicken scratch. All right, now, here is Albert Snyder. Let me see if I can turn this up just a tiny bit.
Burying a child.
Words so well in rehearsal.
Much as having to do, it's like kicking you in the face when you're down. They could have came up and stabbed me, and the wound would have healed. Now, every time I think of my son's funeral, it's tarnished.
And it didn't stop at the funeral. 4 weeks later, Al discovered an article online written by someone from the church, called The Burden of Matthew Snyder.
And it pretty much accused my wife and I of teaching that adultery, we raised him for the devil, and it was just unbelievable to sit there and read.
So Al decided to do something. He took Westboro Baptist Church to court, accusing them of invasion of privacy and intentional infliction of emotional pain. The case went to court in 2007, and Al won. A jury awarded him millions of dollars. The verdict is something Al will never forget.
For some reason, I can't pause this. I'll just mute it and minimize it, and then you can go on.
It was kind of emotional.
But it wasn't the final chapter. Westboro Baptist.
Okay. So that's basically what I wanted to show you. Two very different views of this kind of injury. All right. So Margie Phelps is saying intentionally inflicted emotional distress translates in street talk, in her sing-songy, sarcastic voice. You hurt my feelings, right? And he's saying this is worse than any physical injury. Somebody could have knocked me down, broken a bone, that would have healed, right? But this I'll never forget. And so every time I think about my son, this is what I have to confront. All right, that's his view. And by the way, his damages, and there was plenty of testimony about this, have to do with, the jury must have found that he proved most of these things, which we could easily have another conversation about. Exacerbation of his diabetes, exacerbation of some depression that he'd had before, insomnia. Sometimes he would actually physically just throw up when he thought about this. He was having trouble concentrating, things that you would expect from severe emotional distress and sort of a lack of being able to function. Why else do you think, and let's assume all of this is true, these were all things that happened to him. Why else do you think somebody might want to sue the Westboro Baptist Church as a practical matter? Yeah.
Harassment,
Harassing them?
harassing in person.
Yeah, okay, so, but in this case, let me tell you more about the facts here. That's a very good point. He never actually saw, if you read the trial record and what the Supreme Court described, he never actually saw the protest signs. What he saw was the tops of the signs as he drove past in the car. And later on television, when the thing was being summarized, because one of the things the Westboro Baptist Church does is they pick the most sympathetic cases to pick it, right? Not sympathetic from your point of view, but sympathetic in terms of your thinking, well, why would they do this horrible thing, right? Funerals of children, right? Why did they do that? Publicity, right? They want people to show up and get their message, all right? And it's been very effective. There's not that many of these people, by the way. They're mostly all members of the family, and then there's a few others. There's maybe 60 or 70 of them in all. Yes? Yeah?
Slander, family's name and their actions, could that be one of the...
Well, I wouldn't say slander in the sense that maybe it's not true, but to tarnish them and ultimately maybe to drive them out of business, right? Yeah.
That's what I was going to say, to limit their budget and their means to spread their messages.
Yeah, even $5 million, if that was really, if that verdict had stood, that would have been sort of a shockwave. I mean, and I don't know if they could have survived that. I mean, most of it's kind of a do-it-yourself operation, but they've got some funds, and the trial court, lowering it to $5 million, said, as much as we despise them, you can tell the trial court despised them, right? Punitive damages are supposed to hurt but not destroy, and $11 million, or $8 million in punitives would have destroyed them. $2 million, it'll just hurt, and hurt a lot. But they might think in the future about doing something like this, right? So what do we think about this case? Supreme Court ruled 8-1, that the First Amendment trumped, and that therefore the intentional infliction of emotional distress, which had been proven in trial, couldn't stand. Okay? So when I read a case like this, of course I think about it from a torts perspective, right? Recognizing that there's an important First Amendment value that we need to protect. But I want to know what you guys think about this case, because it's obviously very controversial, and there was a lot of disagreement, even though the court was 8-1. I see somebody whose hand I haven't, yeah, go ahead.
It sounds like they might have been reckless and not intentional in hurting the family's feelings. You know, they may have just not cared if they hurt their feelings.
Yeah, but the court didn't get into that, okay? The court basically said that the First Amendment trumps, we're going to assume that the requirements for the tort have been met, okay? So one thing you might do, and there was a dissenting judge in the appellate court who said instead of getting into the constitutional issues, he didn't think that the requirements for the tort had been met, and that would be a better and a cleaner way to dispose of the case. But the Supreme Court didn't pick up on that dissent. So again, 8 of them thought that the First Amendment should trump in a case like this. So what do you think and why?
Well, I struggled with that case because from my point of view, it was broader than the First Amendment. It actually, in my point of view, hinders the country's ability to then have military that is willing to subsequently go out and
very interesting.
Fight.
That's a very interesting point.
So we can't fight for our First Amendment rights if we don't have a military, and who the hell wants to go to the military if this is what happens?
You know, I have to say, and this is one of the things that I continue to love about teaching law, even though I've been doing it long enough to be mentioned in an article about dying, is that I never thought of that. Okay, that's actually a very good point. I mean, I didn't think about the outcome of the case and all of the sort of media hoopla about it maybe making people less likely to go into the military. I wonder if that's true. If it is, that's a concern. Okay, whether it's one the court should factor in, I think we could debate that. Yeah.
As a veteran, this case actually.
Oh, you're a veteran?
Yes, it tested my resolve, but in the end, this is why we fought and sacrificed, to protect these rights.
But why do they have to do it at a funeral? Can't they go somewhere else?
That's where they feel they can garner the most publicity for the political statement that they're making.
Okay, so let's say, and this was mentioned by Justice Breyer in a concurring opinion. So let's say instead of emotional distress, they had hit Albert Snyder over the head with one of their signs, okay, and harmed him that way.
And that's a criminal case.
It is, but I'm talking about a civil case. But you're right, that's a criminal case, but I don't care about the criminal case. No criminal law will invade these walls, right? Although, as you can see, the law is a seamless web. So a lot of the stuff that we're talking about, First Amendment, constitutional law, right, and tort law, you can see sort of connections there, which I hope you'll see throughout law school.
Commonly referred to as the freedom of speech, not the freedom to debate.
But freedom of speech, I guess my question really is it consequence-free freedom of speech? So they could still say what they wanted to say, right? But people that are injured, I guess my question to you is, what about Albert Snyder's injury? Are you diminishing that because it's emotional injury as opposed to physical, international symbol for physical injury? Or do you think there's something else going on in your objection?
I don't diminish that emotional distress, but
it's a hard case.
It
right?
is, but at the same time, they had a clear political mess. They had a clear message they were trying to convey, and they felt that was the way to get the most attention for their.
We could go back to Greek tragedy, right? And let's do that for just a minute. All right. If you've read Antigone, right? So she actually risks and loses her own life because of the importance of a proper burial and a funeral, right? So she defies the king, right, Creon, and she has this argument with him. And who the heck is she, right? She has this argument with him, and he said, well, if you're defying me and burying your brother against my wishes, because the king wanted him to die in the battlefield, picked to pieces by various, avian emissaries, because he was a traitor. And she said, no matter what he was in life, everyone deserves a proper burial. And she was so committed to that she lost her own life in arguing with him. Right? So funerals are different, and it's not just the legal aspect of the military funeral that sort of highlights it. Right? It's that there's a deep sort of part of the grieving process that gets worked out with the funeral. And so one of the things that Justice Alito points out in his dissent, which is a fairly angry dissent, is, you know, the majority keeps talking about how they stayed 100 feet away and they complied with local law. He said, but the local law is only there because we recognize the importance of funerals. And just because you comply with a statute has nothing to do with this emotional distress claim. One more comment, and then I have to, or a couple more, and then I have to stop because I want to talk for about 3 minutes about the first year experience. But you can see this was to give you a flavor of what a typical law school class is like and the kind of discussions that we might have in trying to work out some kind of doctrine. Go ahead.
I was about to say, if those statutes or those requirements are in place, then the body or the Congress is responsible for reestablishing those requirements, not going into the First Amendment and trying to take away more liberty just because you disagree with someone else's idea.
Well, I think, you know, one of the fallouts from cases like this, and Maryland had a law that required staying a certain number of feet back. The law wasn't actually in effect at the time, but the protesters were actually behind what the law would have required if it had been in effect at the time. But I think you're going to see states trying to create greater zones around funerals, but it wouldn't protect them from the TV broadcast. And one of the things, see, the problem is I can't stop. One of the things that Justice Alito mentioned, and that the court mentioned at trial, was that the signs really were of two kinds. So some of them were general signs about, you know, God hates the U.S. and all of this stuff, and then other ones were, you know, God hates you. You're going to hell. Thank God for dead soldiers. Semper Fi, bags. You know, so all of that was because he was a Marine. All of those things, according to the lower court and Justice Alito, were directed at him. He was a private figure mourning his son. So public figures might make this an easier case because they put themselves in the spotlight. You certainly wouldn't argue against someone's right to do this at the funeral of a president or something. But someone like this who's trying to grieve a person, I think it makes it a tougher case. 1, 2, 3, 4, then we have to stop.
I was just saying, I feel like they protested, so therefore their First Amendment rights, they were allowed to do that. But I think that in doing that, they caused the duress, which now becomes the issue where they tort for. So I mean, I don't see how it's an argument that it was against their First Amendment. They did it.
Well, yeah. So that's a very sophisticated point, and you too make those in your law school. It depends. If we were going to stop them from speaking at all, we'd be really concerned about an injunction, all right? Because that directly takes away the First Amendment right. This does sort of work sort of in a second-hand way by punishing them with death, or by making them liable in damages, and therefore might deter future people from exercising their First Amendment rights. So, but that's more of an attenuated argument. Yeah.
How do we distinguish these people from terrorists? They've supported that 9/11 happened, that we deserve it. I mean, no.
I would say the simple answer to what is a really complicated question is it doesn't matter what you call them. Even terrorists have First Amendment rights. So unless they're doing something terroristic, which it's not clear that this really is, then they're entitled to the same First Amendment rights. Even if you can slap any label. Someone said, remember in a radio show, someone said, but this is hate speech. People said, yeah, it's hate speech, but it's protected by the First Amendment. Yeah.
I have to be concerned with the fact that they may be using their First Amendment rights, but they are, in fact, denying his access to freedom of religion rights by going to his son's funeral. Not only for the surviving family, but also the deceased family member. If he had been alive, he would have been denied those rights. And that has to be a big concern with the emotional well-being, because the poor son is literally rolling in his grave with this kind of outcome.
Not literally, I hope. That would make for an interesting documentary. All right, one more comment, and then...
I just wanted to touch on the First Amendment and actually what exactly it does protect. And from my perspective, the First Amendment gives the person the right to express their opinion. But in this case, it seems as though they tried to express their opinion, but to also intentionally inflict harm.
Well,
so I wanted to know how come, was that taken into consideration, or was there any type of distinction?
In my view, not enough, and I think that's where one can fault the Supreme Court. I think you could make a more comprehensive balancing assessment than the court did. And I think where I most am critical of the court is in its failure they do mention in a sentence or two that they don't undervalue his emotional distress, but clearly they do. They don't really stand the intentional infliction claim up against the First Amendment claim in a way that sort of gives it any kind of respect. So that's my concern with it. And, you know, I think like most Supreme Court decisions, you know, reasonable people can disagree. And I guess I'm sort of giving you my position here, which is that, you know, I thought the court decided the case wrongly. I thought there was a personal element, and I thought if they eliminated that part of it, you know, maybe it's a tougher case. But who cares what I think, right? It's basically about the arguments on both sides, and it's about the strength of the arguments you make. And, you know, I've had debates with even other faculty members about this who think I'm wrong, and so who knows, right? All right, so I've already passed, I'm a minute past my time. I was supposed to talk a little bit about the first year experience, but that's kind of it, right? That's sort of what it is. So I thought I would show you rather than tell you. I guess I would say just a couple of things. One is to keep your sense of humor in the first year. It can be difficult to do that because the pressure can sort of amp up. But, you know, it's not supposed to be this glum, cheerless exercise for a year where you just sort of get through and pass your exams and go on to the next thing. It should be a lot of fun, it should be interesting, and you should be engaged with it. And if things get particularly difficult, you know, sort of try to see the amusing side of the absurdity that you're going through. And to that extent, I encourage you to maintain relationships with people outside of law school because they'll have a different perspective and can maybe calm you down. And the only other thing, well, it can be a little jarring, but really it doesn't need to be. The other thing I would say is maintain a life outside of law school. And the other thing I would say is whether you're an ultra-marathoner or a couch potato or anything between, you should get regular exercise. I really feel like that's the most important thing for a lot of people, is to get up, even during finals, and like, you know, do whatever you like. Some exercise you actually enjoy, all right? Not when you feel like there's another thing you have to do, all right? So find something at least a few times a week. We have all kinds of good neuroscience, cognitive stuff, and population studies that show people that exercise and are fit actually do better in processing stuff. Get some sleep. That's all I have to say. I've already sort of gone over my time, so.
Again, thank you, Professor Culhane. That was fabulous. I have to say, you know, as the Assistant Dean for Admissions, every year, and so often throughout the 16 years I've been doing this, I get the privilege of being proud of the people who I admit. They come here, they're great law students, they go on to very successful careers, and today you've already started to make me proud with some of the conversation here today, so thank you. From here, we're going on to the break. The break is designed for you to get as many questions answered as possible, meet with the student service representatives that are here, with the students, and the faculty will also be here as well. So enjoy the break. After the break, we'll come back into this room for a short financial aid presentation, nuts and bolts of financial aid. Thank you.
Thank you. Hello, welcome to Widener, and I'm sure you've been welcomed thoroughly at this point. What we're going to do is just do a brief overview of the financial aid process, financing your legal education. You all would have received, or I hope you would have received, the packet in the mail that had this booklet in it, and all the information that I'm going to talk about is actually in that booklet that you would have gotten once you received your accepted applicant. There are a variety of sources for financial aid. Financial aid consists of scholarships, grants, and loans. The first source is the law school itself. Widener has a Widener Scholarship Program, meaning incoming awards to students that are qualified shortly upon acceptance. And then we also have, if you receive an incoming student scholarship, we also have an opportunity for you to receive merit-based aid as you go into your second year. We review all of our first-year your first year's academic performance, your cumulative grade point average. So we are looking at how well you did in law school, not how well you did in your undergraduate or on the LSAT. Those awards are made tentative awards are made in the spring of your first year, and then we finalize them in June when grades are available. In addition to our Widener Scholars Program, we offer a variety of endowed scholarships and fellowships. Our endowed scholarships and fellowships are donated by the friends and alumni of Widener. In addition, we participate in the Yellow Ribbon Program. Yellow Ribbon applications generally made available in July. The other source of funding is the federal government. The federal government is the major source of funding for law students. The unfortunate truth of the matter is the majority of available funds is in the form of loans. And the federal government is who you're going to borrow your loan for if you have a need to borrow. The first source is the federal direct subsidized and unsubsidized loan. The maximum amount that you can apply for is $20,500 per academic year. The subsidized portion of the loan is based on your need. That's where your FAFSA comes in. You need to do your FAFSA, your pre-application for federal aid, in order for us to determine your need. There's no credit check with this loan, and the interest rate is fixed at 6.8. If you need to borrow, in addition to the Stafford loan, if you need to borrow more than $20,000 to finance your education, cover the balance of your tuition, or your living expenses, you may want to borrow a Federal Direct Graduate Plus loan. With the Graduate Plus loan, a credit check is required. No credit or good credit is good. If you have bad credit, you may have to, you may be offered the option of having an endorsement, which is basically a cosigner. Now, the majority of students are eligible to receive this loan based on their own credit. What they're looking for as far as credit is no bad credit, no bankruptcies, no discharges, no defaults on educational loans, no 90-day late bills. So for the majority, you will be eligible to access this loan. If you're not, then an endorser is an option. You can borrow the cost of attendance minus any other financial aid, including the subsidized and unsubsidized loans. The interest on that loan is fixed at 7.9. How do you apply for financial aid? You need to fill out the free application for federal aid. That is available on www.fsa.ed.gov. It determines your eligibility for federal aid. In addition, it also checks other databases for other federal requirements such as citizenship, selective service, veteran status, etc. In addition, you have to complete the Widener Institutional Data Form, and that was provided to you in your packet. If you don't have your packet, you misplaced your packet, it's available online. Under what forms do I need on our website? In order to apply for federal direct loans, you're going to need to complete a promissory note. The promissory note for the subsidized and unsubsidized can be found on studentloans.gov. You will log in using your ID that you use to sign your FAFSA. That is your federal PIN ID. You don't need to indicate an amount. The maximum amount is $20,500. However, if you don't feel that you need to borrow that much, you would indicate how much you do want to borrow for the federal subsidized and unsubsidized on the institutional data form. If you're going to need to borrow a Graduate Plus loan to finance the balance of your tuition and or living expenses, you would apply on the same site. It is a two-step process. Last year, this two-step process was not very clear on the website. They have made improvements to that, but I want you guys to be aware that it is a two-step process because it tripped up some people last year. You need to apply for a plus and then select Graduate Plus. That is going to authorize a credit check and is where you will indicate how much you want to borrow. In addition, you have to Graduate Plus loan. If you were approved on your own credit, this is the only NPN you will need to complete because it is a serial NPN. Every year, if you're going to need Graduate Plus funds, you would reapply. But the NPN, as long as you were approved on your own credit, is only going to be done once. There is a federal requirement regarding loan counseling, and you will see that option on the website as well. Washington law requires all of our student borrowers to attend an entrance counseling session on campus during the week of orientation. That entrance counseling session is designed for you, for a law student, where the online entrance counseling may not give you or provide you enough information about graduate student borrowing. Questions? Does anybody have any questions? I answered everybody's questions in the hallway. I can't believe it. Come on. Shyness from law students. Pretend to law students.
Well, if I don't have any questions at the moment, but I'm sure once I start looking at all the information, I will. Are you a good person to email for something like that, or who should we email just if we have basic questions?
We have a basic financial aid email account. You can email me or anyone on my staff. You can give us a call. My email is, I may forward the email to another member of my staff to answer it, but my email is eakel@mail.widener.edu. That is my Campus Cruiser account. You all will be receiving Campus Cruiser accounts once you are registered. That is the school's portal. You'll also, once you are a student, be using that Campus Cruiser account to view your e-bill, to register for classes, calendaring, all kinds of things. Any other questions? Yes.
I asked earlier, but for those who don't know, if you're an extended program, how do you figure out how much to borrow?
Okay. We would come up with a cost of attendance each year. We are just finalizing the cost of attendance. We'll have that out on the website midweek, okay? Your tuition is charged for credit, okay? So an extended division student in their first year is going to be taking 11 credits in their first semester, 10 credits in their second semester. The per credit charge is $12.12 per credit. So if you only need to borrow or you only need to calculate your expenses for tuition, you just simply times that by the number of credits you're going to take.
It's a good estimate for books.
Regular division or extended division?
Extended.
Regular?
Extended.
Extended. Just change it. We calculate $135 per course. Okay. So for regular division, it's $13.50. An extended division, they're taking 4 courses, so whoever can do that math real quick in their head. But you want to figure at least $1,000. Books in your first year tend to be more expensive than they are in your second and third years because you are actually buying more paper.
When we get that, I guess, the initial award letter, would any work studies if we were to receive anything included within there, or are they conceptual?
Work study funds?
Yes.
We actually prioritize our available work study funds to our upper classmen. Okay, and the reason for that is that most of the, not all the jobs, but the jobs on campus that students would need work study for would be research assistants. You don't have any experience, so you don't have a value to a faculty member yet. Also, our students have the opportunity to use federal work study funds to work off campus in nonprofit, nonpartisan agencies during the summer, and they're gaining legal experience. So we're going to prioritize the federal funds so that experience can be given or obtained.
Yeah, I have a question about the IVR. I went to another preview and they discussed this IVR and you made it seem as though everybody qualifies.
Income-based repayment?
Yeah.
Income-based repayment is one of the repayment options for the federal loan program. How it is calculated is based on your adjusted gross income and the Health and Human Services poverty rate. Basically, how they calculate your eligibility is they take the amount of your annual loan repayment, okay? And then they figure out a percentage of your income that you would be required to pay in the income-based repayment. So, best place to look at information for that is ibrinfo.org, or you can look at, actually there's a good example for our students in my exit counseling presentation, which is, last year's is loaded, this year's will shortly be loaded up, because there's an IBR example in there. Okay. Basically what they do is they take and protect some of your adjusted gross income. So if you're making $55,000 a year and your family size is 1, they're going to protect $10,830. And then they're going to calculate what that new adjusted gross income, what 15% of that is. Okay? And that's what they feel is a reasonable loan payment. So for the majority of our students, especially as they enter the workforce, they are going to be eligible for IBR. Other questions? Yes.
Is this presentation online?
Not yet, but it can be. Yeah, we can certainly pop it up there. I'll put it under financial literacy on our website. Yeah.
I've heard of 10-year repayment plans and 20-year repayment plans. Are there other options, and when do you select what
the loan program itself, the loans you're going to borrow, it has a 10-year repayment. However, depending on your level of debt, if you have over $30,000 in debt, you can extend your repayment to 25. If you do a consolidation loan, you can extend your repayment to 30. So the terms of your loan are 10. In order to change them will depend on the debt level and or your decision to consolidate after you leave school.
When do you make that
decision? Not until you're ready to go into repayment.
Okay.
Both of those federal loan paying programs have a 6-month grace period. Okay, so as you're beginning to go into repayment, that's when you're going to be making those decisions. And you can actually change repayment periods on repayment plans on an annual basis. Yes.
I'm not sure if you may have already mentioned this, but how many classes do you take for the first semester? Is it 3?
For the first semester, are you extended or regular division?
For the regular division.
Regular division, I think you're 5.
5.
15 credits.
Okay.
Is what? It's 4 then 5. I don't know why I got a whole crew over here. Actually, we're going to have a student panel next, so if you have more questions about academics, you probably want to save them for the minute. Yes?
If I already have federal student loans from undergrad, do they or can they be combined and then put off until I need to start repayment for graduate loans?
You can, if they're federal loans,
yeah,
you can put them into deferment, an in-school deferment. Okay? You'll have to request that from the you'll have to fill out a form and request it to the registrar. Actually, we report your enrollment, but it depends on if you're in repayment. We're not going to report your enrollment until you're in school for a couple of weeks. So if you want to stop the payments as soon as you get to school, then you want to fill out the form.
Can I do it
yeah, the registrar won't do it. Don't certify it until you're sitting. If they're federal loans, you could include them with your law student loans as in a consolidation. If you have private loans, you're going to want to check out the terms for them because not all of them will allow for deferral. Yes.
Interest is still going to accrue though when you're deferring, right?
Yes.
So,
on unsubsidized loans, yes.
Right. So is there a way to incorporate the cost of that interest into the loan that I would be receiving for law school to be able to pay that interest while I'm doing that?
No. And I'll tell you why. The cost of attendance can only include your costs that you need in order to attend school. And that's not one of the areas that they allow us to include it in the cost of attendance. What we do include in the cost of attendance is there are fees associated with the loan program, and we do include the cost of the fees in our cost of attendance. But previous borrowing and credit card debt is not considered in your cost of attendance.
Just interest accrual on these direct loans, when does that begin?
If you're eligible for subsidized Stafford loans, the interest is paid by the federal government while you're in school and during your 6-month grace period. If you are borrowing unsubsidized loans, an unsubsidized direct loan, and then a grad plus, they're going to start accruing interest at the date of the closing. Okay? You can either pay the interest on them or allow it to accrue. If you allow it to accrue, it will capitalize when you go into repayment. Okay, I went a little over. If you have any other questions, feel free, one, to email me or the financial aid account, two, to call our offices. We, as I said, are just finalizing the cost of attendance, and we'll start packaging incoming students shortly, so you would receive an award letter from us. If you're only going to be borrowing the federal Stafford loan, if you're borrowing it all, you can do your MPN now. We're asking that you wait till May 1st in order to do your Grad Plus application because of the possibility of your credit expiring. Okay. Thank you very much for your attention. Now, what's going to occur next on the program is the student panel discussions. The regular division students are going to stay here.